like the one that Michael Corrigan organised last year, and hopefully get together and have a chat and a pint afterwards as well. Hopefully it won't be too long later in the year when we can do that.
It's after spontaneously just starting to
Just
work.
a couple of housekeeping matters before we start off. Can I ask everybody to put their mic on mute and indeed have their video turned off during the course of this?
Yeah, exactly.
Also, Shane has kindly agreed that the event can be recorded, so this will be available on the Foil website afterwards also. And you can access
that's exactly
using your membership and get login details from Lawrence Bessemer, and if you don't already have that. And just to mention that the Foil website's a great resource. There's a lot of material on there. We're just catching up on Irish material, but there's a lot of UK material which is also relevant. You're free to zoom around that and to download that. And also, there's UK events that are open to people as well if they want to register for those. So anything that takes your fancy, do go in there, have a root around, and do see what is of relevance to you. So moving on to today's talk, I'm very glad to say that Shane English, very highly regarded junior counsel, is joining us today, and he's going to speak about defamation. His talk is entitled, "Who Are You Calling a Thief?" which will give you an inkling that it'll be focused primarily on the shoplifting type of cases, and it's certainly something I'm looking forward to. It's an area I do some work in, and Shane and I were just discussing before kicking off today that we both have had clients in the past and currently who have taken the approach of fighting these claims, even though a lot of the plaintiffs are impecunious and you're unlikely to get your costs back even if you win a trial. And it's had the effect that a lot of these plaintiffs are no longer targeting these defendants. And just thinking out loud, maybe that's an approach that the industry could take, and it would be great because there seems to be an explosion in these types of claims. But I look forward to what Shane says about, and what tips he'll give us for actively on the defence side. Over to you, Shane.
Good afternoon, everybody, and thank you all for joining. I can see a sea of names, most of which I recognise here. Apologies, as you all of you who know me know that I have a face for television, or rather for radio, not for television. So apologies if I'm very close to the camera. Today, I just wanted to go through what I like to describe as the general shoplifting type defamation actions, mainly the ones that we see in the circuit court. I want to have a look at them in general terms. I don't want to overburden anybody with masses of law. In reality, those particular cases, there's only two really important cases. So, but we will need to just have a very quick look at those. But I want to have a look at the practical aspects of it as opposed to heavy, burdensome law, because it's not something that wins the day, as we all know, in the circuit court in these type of cases. I do propose thereafter, just briefly, just out of interest, I think you will probably all find it quite interesting, to just have a chat in relation to, in particular, Section 22, Offers of Amends, and Section 28 of the Defamation Act of 2009, which we still call the New Act, laughingly still call the New Act. In any event, to get started, the basic background to this defamation is that defamation can only be commenced in the circuit court. So you cannot bring a defamation action in the district court. So the first thing that tells us straight away is that there are going to be costs issues. And I'll come back to that in a minute. But in the circuit court, it is a judge sitting alone, whereas in the High Court, they're jury actions at the request of one or other of the sides. So long as somebody requests a jury, they have an absolute right of law to have a jury. Surprisingly enough, and you may well be somewhat surprised, these cases do appear on the odd occasion in the jury list, and I have seen them, and I've been in one or two of them, and they don't tend to get very far. And the reality is that these are cases that could never be considered to be High Court actions. The limit of jurisdiction of the circuit court in defamation cases is €75,000. So it's slightly greater than the personal injuries limit. And for those reasons, one would have to be very, very confident, or there would have to be some very significant issues to even contemplate bringing one of these cases in the High Court. But it does happen, infrequently, but it does. In relation to the statute of limitations, as you probably all know, and I hope I'm not boring everybody, but the statute of limitations in relation to a circuit court action is 1 year. So you have 1 year from the date of the incident. And the date of the incident and the sorts of actions that we're talking about here is obviously very readily identifiable. And it is from that moment that you allege that you have been defamed by the particular shop or a security company. The time is extremely relevant in defamation actions. So there's a whole myriad of case law which says that you must bring defamation proceedings as fast as possible. There is a particular case, a decision of Ms. Justice Dunn, Desmond and the Sunday Times, and that sets out the law in relation to defamation. And it says that there is a particular onus on people bringing defamation actions to bring them as fast as possible. The basis of that is, of course, that if your name has been traduced in front of society, that you have a duty to ensure that your reputation is restored to its, or as best it can be restored, as fast as possible. In reality, while the new act brings in certain reliefs for defamation actions, in reality, the only way that a person can be restored in their good name is by damages. So there's no other way really that somebody can be restored. There are things like correction orders, which has been brought in since 2009 and which are frequently pleaded. Doesn't seem to me that a lot of plaintiffs are particularly interested in them. They do lead the odd time to disputes, and I'll deal with that briefly, if I may, later on. The statute of limitations, by virtue of section 38 of the Act, can be extended for a period of 1 year. So if you have an action that has gone beyond the year, you can make an application to court to extend the period of time, the statute, to 2 years. You can only make that application if you are within the 2-year period. The court has no jurisdiction to extend it after that. So if you even realize sort of 3 days before the end of the 2nd year is up, you must make the application at that stage. There's no point even filing your papers or putting the defendant on notice. They must be made immediately because the court is effectively functus after the 2-year period. That's section 38. There have been quite a number of applications to extend the time. There's been quite a number in the circuit court. They haven't gone very well. And there was really, up until quite recently, there was really only about 3 or 4 cases, all of which were refused. They leave to extend the time to 2 years. All of them were refused. The first case was a case, and I always get this name wrong, I don't know why, but Tulisa Kostanovas, who regularly appears, as I understand it, on various shows like X Factor. I have never yet appeared on X Factor myself, but I'm hoping. In any event, that was a decision of Mr. Justice Kearns, in which Mr. Justice Kearns refused to extend the period of time. That case was appealed to the Court of Appeal. The Court of Appeal were told on the morning it was due to be heard that the case had been settled on such terms that were so confidential that they were not allowed to actually tell the court what the terms of the settlement were. But Mr. Justice Kearns, as I say, refused to extend the time. There has been a number since, and they are cases of O'Sullivan and the Examiner. That's the case where the former Garda Commissioner tried to extend the time within which to bring proceedings against Examiner publications. I was in that motion. That was refused by Ms. Justice Pilkington. There was another case, Darren Proudfoot against MGN, again refused. It's a very high bar to get the period of time extended. To my knowledge, there has only been one extension of time, and that was in a case where one brother was suing another brother in relation to a will suit and an alleged defamation. And that case is O'Brien and O'Brien, and that was a decision of Ms. Justice Lee Rafferty. And for very, very specific reasons, that case allowed the extension of time. So in reality, you're unlikely to get an extension of time. And certainly in a case such as the ones we'll be dealing with this afternoon in relation to the Circuit Court, you are certainly very unlikely to be in a position to extend the period of time beyond the 1-year statute. Because Circuit Court, because defamation can only be commenced in the Circuit Court, it tends to be more expensive. The fees tend to be more expensive, and they are a big problem. And the reason that they're a big problem is irrespective of the amount of money awarded in damages. So it doesn't matter if a court awards somebody 50 euros, 100 euros, 300 euros, it doesn't matter. They're entitled to recover costs on the Circuit Court scale because the Oireachtas in their wisdom has said that this is a tort that is of such significance, it can only be commenced in the Circuit Court. Interestingly enough, the General Data Regulation Act, the new act, that is similarly, if you have a case in that, it can only be commenced in the Circuit Court. I think that's a very bad idea for both acts and makes all of this extremely expensive potentially. One of the problems with cases like these are, there's everybody, I suspect everybody online here has a view and is aware of the type of value a shoplifting type case has. And they tend in the main to be very small. They are not big money. I mean, your average case, depending on how good or how bad it is somewhere between starting at 4,000, maybe going up to 7,500, 10,000. Very, very few of these cases that do succeed in the Circuit Court, and not very many of them do, by the way, but the ones that do succeed, very few of them attract damages in excess of that. I'm only aware of one case, and it was many years ago, and it had very particular extenuating circumstances where the person bringing the defamation action actually suffered a heart attack as a result of the stress induced by what was an admitted and assessment only defamation by a large company. So, and that even then the award in that was 18,000 euros. So they don't attract a lot of money, but they are expensive to run. As a result of which, the question often arises, and I think it arises more and more often, where people say, what is the point? Most of the people who bring these claims are impecunious, unlikely that the defendant is likely to be able to recover the costs of these trials for them. But my certain experience is that larger companies and also insurance companies now take the view that if you don't challenge these cases and you simply give 3, 4, 5, 6, 7,000 all in to a plaintiff and their solicitor, you're going to just get more of them because they're seen as sort of low-hanging fruit. People will say, well, look, sure, you're bound to get 4 or 5 or 6 grand, and there'll be a certain amount of that we'll take for damage or for costs. But people are anxious.
Can you hear me still?
People are anxious that.
Yeah.
Sorry, I think that somebody just came on the line there, but
yeah, I'm in. I was out in. Oh, better actually mute.
Right. People are anxious, I think, and they should be anxious to run them. I'm aware of several larger companies that run them, take a view that they are all to be run, and they have seen a reduction in the cases. And the reason why they've seen a reduction in the cases in reality is because solicitors, plaintiff solicitors, very seriously take a view, if we bring this case, if we bring this defamation action in the Circuit Court against this particular company, it's likely that it will be run and there will be no money at the end of it for anybody. And I do think that that is an important thing for an insurance company or for a large retailer, whoever, to consider. Frequently, the policy excesses on these, where people are lucky enough to have insurance, they're frequently a policy excess of something like 5,000 euros. When you consider that the vast majority of these cases are actually brought against small retailers, Centras, Spars, a very large number of actual pharmacies are finding this, and I'll come back to that in a minute. You're talking about a lot of money, and you're talking about potentially a couple of these cases could be enough to put a smaller firm, a Spar or a Centra or a small pharmacy out of business. But they are cases that need to be discouraged. The best way of doing that is by running them. The type of cases they are is what would have ordinarily be called in the old days before the 2009 Act slander cases, i.e. oral defamation, as opposed to something published in a newspaper. They tend to have very limited publication. Publication is obviously a key ingredient of any defamation action. So if I speak of somebody to them, so if I speak from myself to another person and it's just the two of us in a room and I say something of them which is highly defamatory, they're not defamed because they cannot be defamed to themselves. It is only when those spoken words are published to one or more persons that you have a proper ingredient of publication, which allows the defamation tort to become a proper tort. So you must have publication. Publication is a key ingredient to any defamation. And believe it or not, there are defamation actions that are published maybe to one or two people, and yet people recover money on foot of that because the element is there, the publication is there, but it does affect the amount of damages that should be awarded in any defamation action, the size of the audience to which the defamatory words were spoken or they were written. Your general type of claims in the circuit court are SPARs, Centras. Pharmacies are becoming a massive target. And the reason they're becoming a massive target is if you go into a pharmacy and you go to a counter and you can pick up something, a very small item like a lipstick or whatever, it might be 25 or 30 euros, so it's a fair bit of money, and you can secrete it about your person. The problem is, of course, that in a lot of these cases, people are not actually stealing, and indeed they're not even trying to steal. They're trying to give the impression that they're stealing and hoping that somebody will approach them and challenge them. So pharmacies see that because they've small items, they're very expensive, some of them 30, 40, 50 euros, their staff go and challenge somebody and all of a sudden all hell breaks loose, and the owner of the pharmacy or the insurer saying, God almighty, it wasn't worth it. You should have let them go out the door. That's completely, in my view, wrong. I know it's easy for me to say that, it's not my money, but it is wrong. I have represented people who have defended defamation actions where people have been accused of taking plastic bags worth 17 or 20 or 25 cents. But they've done it on a principle and on the basis that they don't want this coming in and out every day of their stores and their shops. Some customers, the problem is this as well. Some customers are absent-minded. They go to shelves, they pick things up, they put them into a trolley, or they take it back out again and they put it back on another shelf, the wrong shelf, or they might put it into a bag that they have with them. And some of that is people making genuine mistakes. And they're approached and people are concerned, you know, I don't think this person is stealing, but I do think they've forgotten to produce that for payment, or I think they may have put it back, but I don't know, did they put it back on a different shelf? So some of that happens and it's not deliberate. Then there's the other kind that is deliberate and is a proper real theft. So somebody comes into your shop with the intention of stealing from it. But the ones that we see in the courts, not all of them, because obviously certain plaintiffs are accused of theft and they haven't been stealing, or it was not their intention to steal, or they weren't trying to look like they were stealing. But a lot of claims, and I'm not suggesting all of them, but a lot of claims that come into the courts are claims where somebody has effectively sought an action. So they've gone in, they've picked something up, it hasn't been clear to the shopkeeper that they've put it back and they've gone out the door. And when they're approached after they've left the shop, all hell breaks loose because in point of fact, they don't have the item on them, and they're now saying, well, you're accusing me of theft and that I'm a thief. That's from a shopkeeper's perspective, that's a terrible thing, because you really do have to wonder, is it worth it? And I keep saying to people all of the time, it is worth it. If you look at that case from the plaintiff's perspective, and I know our interest here really is the defendant's perspective, but if you were a plaintiff solicitor and somebody comes into you and says, look, I was accused of stealing in a shop, do I have a case? A number of issues arise. What sort of a store were you in? Was there a proper system in place? Were they negligent in or about the use of their system? So in other words, if I go to a market and I take something and somebody challenges me, well, he clearly, if you have a stall owner, they're unlikely to have CCTV footage. They won't necessarily have trained guards. It's very unlikely. All of those issues come into play if you're a bigger store, if you're a massive retailer with CCTV footage, cameras available to be immediately inspected to check the cameras, did that person actually take it? So a security guard forms the view that somebody has taken a bottle of wine or whatever, some goods. They can go and check CCTV footage. The court will question, did they do that? Did they have a procedure in place and did they follow that procedure? These are really important from the perspective of both defending these cases and bringing these claims. Because if you train your staff to do something and they fail to carry it out on an occasion, then you get yourself obviously into a lot of trouble because you've given them the training, they know what they're meant to do, but they haven't done it. They haven't carried it out the way they were trained to carry it out. And now we slip into the negligence area, and that's potentially problematic. The one thing that I think defendants must understand, and it's something that I find, because representing a lot of these cases, I meet a lot of people, I meet a lot of security guards, I meet a lot of managers, I meet a lot of staff, all of whom get nervous. And so they look, they think somebody has stolen something, they challenge them, and they're proven to be wrong. So the person doesn't have anything on their person, they haven't taken it, or they have said, and frequently people will say, oh, no, I didn't take that. I left it back on the other shelf. I left it beside the deodorants, or I left it, whatever. And so now they're going, oh, they didn't take it, so I better not say anything. In point of fact, the whole crux of the defense in a defamation action depends upon the staff or the security officers or whoever makes the challenge of the customer believing that the person did take it, that they had formed a bona fide view that the person had removed something or had intended to remove something from the shop without paying for it. That's the whole crux of the defense of qualified privilege, and we'll come to that defense. So rather than staff or security officers or managers or whoever rowing back from their position and saying, oh, well, I didn't really think they had taken something. I was really just wondering where they had put it, or I knew they'd put it back, but I was wondering where they put it. That is completely the wrong approach. It sounds counterintuitive, and I can see people when I'm saying it to them in consultations going, oh, you can't be right about that. The reality is this: if you have not formed the bona fide view they have stolen something, or they are trying to steal something, or they have left without paying, then you don't have the benefit of qualified privilege. So in point of fact, staff should be told, and people dealing with customers on a daily basis should be told, yes, if you form the view, you're entitled to say it. You are absolutely, as a matter of law, and we'll come to the law on it, entitled to say that. But it can't be wishy-washy. You can't think it and then try and get out of it or backtrack from it. That's a killer and will kill any potential defense that you have. The defenses in a defamation act are set out, in a defamation case are set out in the Defamation Act. They've always been common law defenses to defamation. Justification was a common law defense to justification, to defamation, sorry. Truth is section 16 of the Defamation Act, is the statutory defense of truth. Now, truth in a defamation action is a very grave thing, because anybody who pleads truth in a defamation action, so when might we plead truth? Truth. Somebody comes into your shop, they steal something, you see them stealing it, they put it in their pocket, they walk out the door, they're arrested, they're charged. But believe it or not, don't all laugh at once. People in those positions do sometimes sue for defamation. Rarely, but they do. And I have seen people do that, and I've put defenses into it. And you plead truth. And it's very clear, and you can establish and you can prove, yes, this person, I called this person a thief because in fact they are thieves and they've stole something from my shop. You must be certain. If you plead a defense of truth, you must be certain. If you plead truth and you don't manage to establish it before the court, the plaintiff will almost as a matter of certainty be entitled to aggravated damages. Because what you have done is you have compounded the defamation because you have sworn under oath that the person is in fact a thief. You have led that evidence in court, and you have, if you haven't established it, you're a goner, because it's rarely that anybody who pleads truth in an action and who fails to succeed doesn't end up paying aggravated damages. It's an extremely difficult defense to bring home in a defamation action. It has all sorts of other complicating factors in all sorts of other sections of the Defamation Act. So, for example, if you plead truth, one of the things that can be taken into account in extending a defamation action, so to extend the period of time, the statutory period of time, one of the things a court will consider is whether or not the defendant intends to prove or to plead truth. The reason being, the bar to extend the period of time to bring your action is slightly lowered for the plaintiff, because the court says, well, this is very serious because the defendant or the plaintiff says you defamed them, and you're saying we didn't defame them because what we said about them was true. So pleading truth has all sorts of ramifications in defamation actions. That's just one example. It's an unusual plea. It doesn't happen very often. I have pleaded it, I have run it, and I have won it. I'm quite certain other barristers have also pleaded it and run it and won it. But if you don't, you're in trouble. And the client needs to know that very early on, that, okay, we can go this path, but it's one we need to be careful about. Qualified privilege is the main defense in these types of cases. What is qualified privilege? Qualified privilege is simply this, that I have a duty and interest, and there is a reciprocal duty and interest. If I'm a store owner and if I own goods, or if I'm a member of staff of a store, or if I'm a security guard employed by a store, I have a duty to ensure that my employer's goods are not stolen. If I believe you have stolen them, then you have an interest in hearing what I have to say. So that establishes the duty and interest perspective, which must be present for qualified privilege to apply. That can only be defeated by malice. Malice is legal malice. And that legal malice is things like over-publication, extensive publication. So for example, if I believe that somebody is walking out of my shop and has stolen something, and rather than going to the front door to challenge them, I get onto the tannoy system and I announce over the tannoy system that the man there in the black jacket and the red hair has stolen something from the store. That is something that a court could take into account and say, well, that was legal malice, because that was completely improper and inappropriate. And therefore you are not entitled to the defense, while you would ordinarily have been able to rely on qualified privilege. In point of fact, it is defeated in this case because you went about it in such a stupid way in asserting your qualified privilege and in challenging the person who you believe had stolen something. So you've got to be very careful about that. You can't, you must consider things, for example, how do I approach the person? Where do I approach the person? Your staff, and this is a technical minefield, because people will frequently say to me, oh, well, look, I could see her going out the door, but I didn't want to stop her until she'd gone past the cash register. Because another important thing is you don't stop somebody and challenge them and ask them, have they stolen something or have they failed to pay for something, if they still have an opportunity to pay for it. So if there's a cash desk still waiting for them to pass through. But the problem about that is a lot of fellas say, yeah, but that's fine. But they did. The cash desk is at the door. I allowed that person go past and through the cash desk. They didn't pay, but now they're out in the air and they're out in the public, and they're either out in a shopping center in a mall with a load of other people, or they've walked out onto a footpath. And now I feel, actually, I shouldn't be doing this in this area. That's not correct. Provided you do it discreetly, quietly, with no aggression, and simply put it as a matter of fact to the person. Staff need to be properly trained about this, but you put to the person as a matter of fact, excuse me, I believe you have something in your bag which you haven't paid for. Don't dilly-dally. Don't be asking, you know, oh, can I look at your receipt? Are you sure everything is on the receipt? Did you take to it? I believe you have something in your bag that you didn't pay for. If you're wrong about that, fine. If that's the view you formed, you're protected by qualified privilege. But do it discreetly. Don't do it in an aggressive or an improper way. Don't use wandering language or over dramatic language. The stop thief notion, none of that is clearly, that's not relevant in the world today. But you can say it, and you can say it frankly, and you are entitled to the protection. And we'll see from a couple of the cases that the courts recognize that even where you have said this and other people have overheard it, that's okay. You're entitled to do that. So they're effectively the main defense to any of these actions is qualified privilege. Now, there are two cases of interest, and there are really only two cases. I mean, it sounds ridiculous. There are other versions of these cases. There's some decisions of Mr. Justice Kelly and others. But these are the two cases that you really need in your armory if you're going to defend proceedings like this. And the beauty about both of these cases is that they happen in two very different types of locations. So the first case is an old case. It's a 2004 case, and it predates the 2009 Defamation Act, but nonetheless is an excellent determination. It's a written judgment of Mr. Justice Adrian Hardiman. It's a case of McCormick and Ulchthorn, 2004 IEHC at page 431. This is a magnificent decision. It really is. It's Adrian Hardiman and at his best in an area he loved. He loved defamation, and it's a really full-on analysis of qualified privilege in these type of cases. And I don't intend, I think it would be a gross waste of your time for me to start reading chunks of cases. You can get the case, you're all more than capable of considering the case and getting the best out of it. But it's beautifully, apart from anything else, it is actually beautifully written. It is a fantastic treatise on the law of defamation or qualified privilege and how it works. And it says this, the basic facts of the case are this. Mr. McCormick is a former superintendent. He's attending the Cavan, I think it's the Cavan Milk Market. So it's a market where people are selling from various stalls. Mr. Ulchthorn is a man who sells potted plants. Superintendent McCormick comes to his stand. He picks up a potted plant. He looks at it. He walks away. The agreed evidence is it was a reasonably busy market day. Mr. Ulchthorn, being convinced that the chief super has robbed a pot plant from his stall, chases after him, puts his hand on his shoulder, turns him, and says to him, "You stole a plant." And the chief superintendent says, "No, I didn't." And he said, "I can see it in your bag." The chief superintendent pulled out the potted plant out of a bag, and immediately Mr. Ulchthorn realized it wasn't his, because his potted plants only came with, I think it's red or green pots, whereas this was a different colored one and it was from somebody else's stand. And he immediately apologized. The chief superintendent brought an action in the circuit court. The circuit court found for the chief superintendent and gave him damages, not just for defamation, but also for assault, the technical assault of putting your arm on a person to pull them back. Mr. Justice Hardiman, as a Supreme Court judge, was sent off to hear circuit court appeals early on in his career on circuit, sitting as a High Court judge, and this appeal came before him. And he gave, as I say, a fantastic judgment in it, in which he says effectively this. He says, look, this is clearly a case of qualified privilege. We live in a world today where some people want to steal your goods. This is a small guy. The loss of a plant or two could make a big difference to him on any particular day for his takings. He didn't scream, he didn't roar. He shouldn't have turned the man, so he shouldn't have put his hand on him. And he didn't have time to consider the words he should use. So he didn't have time to think to himself, what are the correct words I should be using here? Should I be inquiring? What should I be doing? And Mr. Justice Hardiman said, we live in a world where people don't have the time to do that anymore. And we must accept that. Things have moved on. This is a small business. He didn't have access to any fancy CCTV footage or anything like that. He couldn't double check. It was an instantaneous moment. He had to check it out there and then, and he did so. And Judge Hardiman found that he was absolutely entitled to qualified privilege. And the important point to bring home from this is he was wrong. He knew he was wrong. The minute he took the pot plant out, he realized he was wrong. But the moment he challenged Superintendent McCormack, he believed in his own head, he bona fide believed that the pot plant had been stolen. It didn't matter that he was wrong, and it doesn't matter that a member of your staff or a security guard or your manager or whoever challenges somebody and they're wrong. It simply does not matter. All that matters is that they really believed at the time that they challenged the person that they had tried to steal the goods. And the interest, by the way, is not just for the owner of goods. So if I own a shop and I have 3 members of staff, they're entitled as my employees. It's not just me as the owner, even though they may technically be my goods and they may technically not be my employees' goods, that person is entitled to challenge on my behalf as an employee, as is a security, bona fide security firm, or indeed any other person in the shop acting with my authority. So that's a very important decision of Mr. Justice Hardiman. There's a subsequent decision post the 2009 Act, and it's an important case for the larger retailers. It's a case called Elga Holbrook and Dunn's Stores. It's an unreported decision of Mr. Justice Peart, and it is an interesting case for this reason. The plaintiffs in this case walked into a large Dunn Stores premises, and they went around the shop and they were looking for various things, and they picked up a slab of beer, and a security guard believed that they had gone out the door of the shop with the slab of beer. And before he went out to challenge them, he asked one of his colleagues to look at the CCTV footage. And the colleague said, well, I can see them taking the slab of beer, but I don't see them paying for it. And so they decided they would challenge these people. By the time they came to challenge them, they were at their car. In fact, one of them was actually inside the car. So not happy with simply running across the car park of the Dunn Stores, like literally running across this was the agreed evidence. The 2 security officers ran across the car park. One of them came to the passenger door and pulled the passenger door open. The other one, while that was going on, was saying, you've taken a slab of beer, you've taken a slab of beer. 2 people get out of the car, say, absolutely not, we haven't taken a slab of beer. They're marched back to the shop. They're brought into the shop. And when they get into the shop, the guy who had been challenged said to the security guard, there is the slab of beer. And they put it down just before the cash till. They hadn't taken it out, hadn't removed it from the shop. They had picked it up, they'd carried it about, they'd put it in a trolley, they'd taken it out of a trolley, and they put it down before they left. And that's why they hadn't paid for it, because they hadn't bought it. So my gut instinct, certainly before Mr. Justice Peart's decision, would be this is going to be a very challenging case, because there's a lot to take in there. This is a case where, okay, they have formed a bona fide view. They've used their equipment, so they Dunn Stores are lucky enough to have CCTV footage. Their security staff followed the agreed protocols, look at the CCTV footage, make sure, be certain that they have done this or that or the other. They get out the door. But I mean, they create effectively almost bedlam. I mean, pulling of doors open and all of that. But Mr. Justice Peart, in his decision, says, actually, no, this is the way modern society works. This is the way that people must deal with things. Things like this happen incredibly fast. So coming on from the theme of Mr. Justice Hardiman and McCormack and Ulstorn, Mr. Justice Peart said, this happens very fast. People have to make very fast decisions. The security guards had the good sense and had the insight to go and check the video footage. They did follow their procedures. And yes, they came out and they ran across, but what are they to do? The person could be gone, and if they're gone, the whole purpose is to try and defeat the theft. If they're gone and you can't defeat the theft, then what's the point in having security guards? And while, again, as I said to you, I'm not going to read because it's total waste of your time, but there is just one passage of that. It's it's the High Court sitting on circuit in Cork. And he goes through and he does an analysis of the law. But one of the more important paragraphs is paragraph 43, and it's a short paragraph, but he says, I'm satisfied that the incident which occurred in the car park as described by the plaintiff and her partner is an occasion of qualified privilege. Shoplifting is something which sadly happens all too frequently. I do not need expert evidence to make that comment. It is inevitable that stores will employ security staff and install security equipment in their stores in order to limit as far as possible the losses which occur through thefts of goods. Security staff must be entitled to take action when they have reasonable grounds for believing that an offence may have been committed, without running the risk that their employer will be sued for defamation. However, I emphasise reasonable grounds. If there are no reasonable grounds for the suspicion, or if reasonable steps were not taken in order to see if reasonable grounds for suspicion exist, the employer may well be vicariously liable. So what he's saying is very clear. Yes, you employ security guards to stop people stealing from you. Stealing happens. People do steal. Sometimes those security guards who are acting perfectly legitimately, or members of staff acting legitimately, get it wrong. They make a mistake. We didn't realize, we're sorry, and that ought to be enough. People are entitled to protect their goods, and people are entitled to challenge other people, and they're entitled to be wrong about it, provided they do it right. That's the main bits of that I wanted to talk to you about, and that I think is of some benefit to anybody online who's interested in this area of law, or who has to make decisions in terms of insurance for companies, whether or not to run these cases. These cases are eminently winnable. There is just no doubt about that. Indeed, my experience in the Dublin Circuit Court is the courts don't like these cases. And they don't like them for the reasons expressed by Mr. Justice Hardiman and Mr. Justice Peart. They don't like the fact that we all know people steal. And sometimes they've stolen goods and people go out of business. And sometimes other people who may have been acting a bit messily but weren't intending to steal are challenged. And provided you do it right, provided you form the bona fide view that they were trying to steal, and provided you don't overpublish it, or you don't act the aegis, or you don't use bad language, not bad language, but you don't use inappropriate language, you can do that and you can have the benefit of the law. The other elements that normally come with these cases, and the bit I didn't tell you about the the McCormick and Ulstorn decision, Mr. Justice Hardiman, is that while on appeal, the defamation aspect of the case was dismissed, the assault charge was upheld. Not charge, but the assault damages. And I think that he had been awarded in the Circuit Court about 3,200, I think, for the assault. That was upheld. And so it is very important, under no circumstances should anybody ever be touching somebody or holding them back, unless they actually have caught red-handed in the act of stealing and you're waiting for the guards. But you shouldn't be generally doing that in cases such as these. And the false imprisonment is another aspect of these cases, which plaintiffs are more and more pleading the false imprisonment aspect. If you win the defamation aspect, if the court believes that you have formed a bona fide view even though you were wrong and you didn't behave badly, my experience is that the false imprisonment is going out the door as well, in the main, unless there's video evidence of 6 security guards standing over one 95-year-old granny. That's not going to do you any favors in front of a judge. Of course it isn't. But in the main, if the defamation bit goes out the door, normally the false imprisonment bit goes out the door. Now I'm looking at the clock and I see it's 5:15 and I was told to shut up at this stage, but if you would indulge me just for literally 5 more minutes, because there are two aspects of this act that I think will be of interest to people online, and they are the declaration declaratory relief under section 28. So that's, you can bring a defamation action, whether you consider to be monetary value in the High Court or the Circuit Court, so over 75,000, you could bring a defamation action under section 28 summarily, effectively. And if you do that, you are not entitled to recover damages, and you are not entitled, if you lose that, to sue on foot of that case anywhere else. You might say to yourself, why would you do that? It hasn't happened very often. There are 2 cases, Larry and Smith, and that was the television journalist, Sam Smith, against the former minister, Michael Lowry, who sued him under Section 28. It was the first case of its kind to be heard. Judge Heenahan, who was then a circuit court judge, heard it and dismissed it. And the grounds for dismissal are this: if you have any defense at all, if you can show as the defendant you have any defense at all, you are considered not that the plaintiff cannot succeed in their summary action. So that's a huge risk. So any plaintiff who does this it's a hiding to nothing. There has been none, to my knowledge, that have won. In point of fact, there is one that kind of only half won. That's a case that I was in, called Waters and Star newspaper. And to cut a very long story short, the newspaper published an article about a well-known criminal who had been released from prison. In the course of writing that article, they identified Mr. Barry Waters as an intimate partner. The implication was an improper relationship. And so Mr. Waters sued. But because Mr. Waters had no reputation in reality, because he was in prison for child pornography, he nonetheless sued. And he sued under this act, and he said, that's defamatory of me, it's not true, and you don't have a defense to it. But because there was no damages going to be awarded, the court, and it came before His Honour Judge Matthews, and that is a case that, unfortunately, for the defence in that case, the Star newspaper, Mr. Waters won it because of a 32-page decision of His Honour Judge Matthews. And I don't wish to be disrespectful to Judge Matthews, who I'm very fond of and was a great judge. I've reread it about 100 times and I still don't understand it. But he said that the plaintiff had what was known, something which is unknown to the law in any other jurisdiction and never known here again since, as a residual reputation. Now, that wasn't too bad because the newspaper, they paid the plaintiff's costs, and we were directed to issue a correction order. If the correction order couldn't be agreed between the parties, the correction order then had to be, the judge had to decide what the correction order would be. The parties agreed the correction order. The editor of the newspaper, who's no longer the editor, but was a very famous and excellent editor, produced the correction order, and beside it, he put a headline which says, "We've been told by the court to apologize to Mr. Waters. Do we mean it? F-U-C-K, we do." And unfortunately, a week later, we were all back in court and we were fined €40,000 for contempt of court. So not a good idea. But that section is unlikely to be used, to be honest. And it is really only used by somebody who is a multi-billionaire who's not interested in money but wants his reputation restored immediately, or somebody who has no reputation and no money and wants to take a punt. The final thing I'm just going to say to you again, very briefly, Section 22, offers of amends. These have become a hot topic in the last couple of years. The first reason they became a hot topic was it had to be determined by the court whether or not, if you make an offer of amends, so a newspaper, for example, in a case that they're sued for defamation, if they say, yes, we got it wrong, you're right, we did defame you, and now we're going to make you a formal offer of amends under Section 22. You don't put in a defense, you make the offer. You're automatically entitled to a reduction in any damages that are awarded, and the matter proceeds to be assessed for damages if you cannot agree the damages. The first row that was in that case was in one of the cases called White in the Sunday World, which is a case which I was in, was a case in which the row was whether or not, having been defamed and bringing an offer of amends, whether or not you're entitled to have a jury assess the damages. So I gave advices that my view was, and subsequently other people held the same view, that it was not a case that would be heard before a jury because it wasn't a defamation action, it was a hybrid, and that therefore it was for a judge sitting alone to determine what the amount of damage is if the parties couldn't agree. And we ran that point in the High Court and we lost it. So not to be done in, we appealed it to the Court of Appeal and we lost it. So not to be done in, we decided to make an application to be admitted to the Supreme Court, and we were admitted to the Supreme Court, and on the 10th July 2018, we lost it. So we only lost it 3 times, but in fairness, what it means is this: in an offer of amends case in the High Court, the plaintiff is still entitled to a jury to assess the damages. And while that may or may not be of some significance, it subsequently turned out to be of massive significance in a case called Higgins and the IAA, which is the first case of its kind where an offer of amends was made by the defendant and which a jury came to determine. And this is the good news for those of you online who have checkbooks and find yourselves writing checks for these things. The jury in that case awarded Mr. Higgins they awarded him 300,000 general damages and 130,000 aggravated damages. They reduced it by 10% because the defendant was entitled to a figure, some figure. It's not defined. It's a matter for the jury to determine what that figure should be. They reduced the overall award by 10%, giving Mr. Higgins a full value of his case of 387,000. That matter was appealed to the Court of Appeal. The Court of Appeal said, you shouldn't be starting anywhere close to these figures, as they had said exactly the same thing in the case of Christie v TV3, which was a case that had been heard by a judge sitting alone. But they said you shouldn't be starting here, and rather than send it back for a retrial, which the Court of Appeal were entitled to do, they decided to substitute their own award. And they gave the plaintiff 70,000 for general damages and 15,000 for aggravated damages, having taken off what they said was much closer to 30 to 40% of the award. So that's, I think that's more or less it. And I'm happy if there are any questions, if anybody has any questions.
Shane, thanks very much for that. First of all, very stimulating talk. I think your passion for your subject matter comes through, and something that struck me, I've never seen anybody speak about McCormack decision. So now, you said before the talk that you're happy to take questions as long as nobody's correcting you, but I'm going to correct you on one thing. It was Limerick Market, not Cavan Market, and I'm saying that because I'm from Limerick. That's one thing.
I knew I'd get it wrong.
But I'm going to be selfish and ask you a few questions myself first, just to get us started. And I see there's one in the chat room. And just for everybody else, if you do have a question, please do put it in the chat room and I'll pick them up. But what would you say about children as plaintiffs, and does that change your approach to cases like that? That's question one. And question two, on shoplifting cases, is there a right as a defendant to, or is there any way of getting a potential or getting a plaintiff's criminal record, getting access to that? Is it only in an instance where, by the Gardaí, I mean, is it only the case where the Gardaí are called to that specific shoplifting incident that you can have access to the Garda and their records for that specific incident, or can you have access to their prior criminal record? Okay,
well, the first question in relation to children, bizarrely, I don't understand these type of shoplifting cases that are brought by, and they are brought in some cases by next friends for 3 and 4 and 5 and 6-year-olds who've picked up something on a shelf and not put it back. And the mother or father's approached and asked, did John take that, or did he put it back? And they sue. Nobody in their right mind seriously believes that that child was not paying, because nobody believes that 3, 4, 5-year-olds carrying around cash to pay for their own goods in any event. And certainly none of my children ever carried their cash, and they're considerably older than that. But that, so it doesn't seem to me to be right. When you get to the older age, 14, 15, 16, people bring those actions. I think it makes no difference at all. I think you should be defending those cases as you should any of the others. I don't think the age of the person is relevant, although I laugh at the ones that bring them in for the cases of 4, 5 and 6-year-olds. In relation to the second part of that question, in relation to criminal records, dangerous thing to do. You've got to be 100% certain you've got the right person. However, if you have got somebody who you believe was shoplifting and it transpired they were not shoplifting, you can adduce reputational evidence if you have the goods. You can't, it's very hard to get the goods because you can't, guards don't normally they won't give you a list of somebody's convictions. But if a man is suing you because you have called him a thief and you are wrong about that, and you've put in your defense of qualified privilege, and it transpires he has 36 convictions for shoplifting, then absolutely you can plead reputation, and you can say that his reputation in the community is that of a shoplifter, but you are going to need to call a guard and you're going to issue a subpoena duces tecum, and the guard is unlikely to tell you what's in his bundle or in his file, but you better pray to God that it is what you think it is, because if it isn't, you're into aggravated damages time. Very good, Shane. And I'm just going to run through some of the questions. The first one's from my colleague here, DWF Nicola Rafferty. What about the issue of negligence regarding leaving tags on as separate to defamation? It's a slightly different issue, yes, but remember this, and this is the point I always make. Where somebody pleads negligence, and they plead, well, you left the tag on and that's negligence. They have to show loss. If it's a straight negligence action, they have to show loss. So one of the things that every defendant solicitor in every defamation action, the last question in every notice for particulars ought to be, please confirm that the defendant or the plaintiff has no special damages. If there is no loss arising from that negligence, then they've no case. Then if they want to proceed on the defamation aspect of it, it's only as good as any other defamation case, ignoring the negligence aspect of it by leaving the tag on. They are slightly more problematic. They are more likely than to succeed than your standard defamation action, but I think they are equally winnable, and I think they are ones that can be fought as well.
Nicola also has a follow-up question. Obviously, you spoke about these cases running together with the false imprisonment element, but Nicola's question is, can you run a personal injuries claim and a defamation claim in the same proceedings?
You can, but you must remember this, that there's a case called Lonhro and Al-Fayed. So Mr. Al-Fayed, the former Harrods owner. It's a decision of the House of Lords, which says you can only seek defamation damages in a defamation action. So where somebody tries to sue you for defamation, but they have not brought it under a defamation action, they're not entitled to succeed as a matter of law. That's the reality. But yes, so you can have a personal injuries action and you can have a defamation action, and you can tag both on together. But you must remember that your defamation action must be pleaded as precisely that, a defamation action.
Very good. You mentioned, actually, this is my question again, you mentioned a range for damages for the defamation element. What about the false imprisonment? Is it broadly similar, same amount on top again?
No, you wouldn't add the same amount on top. It's a portion, in my view. It's closer to maybe a third of the general damages for the defamation. That does obviously depend. There are some cases where everybody was going very well. I mean, I can think of one case I was in where everybody was playing a blinder until they literally had 8 people stand around the 79-year-old woman in the shop, at which stage the judge almost exploded. And that was an unfortunate outing on the false imprisonment side. But in reality, they are a portion of the defamation damages. And I genuinely do believe that in most cases where the defamation fails, the false imprisonment, unless it's obscene or there's some really bad element to it, normally falls away as well.
Okay, another question. Does Shane have any thoughts on employees using their own mobile phones to catch a thief in the act or record the alleged thief if they go after being approached, rather than the CCTV?
Well, I think you run into all sorts of other issues there, GDPR, privacy, breach of privacy. Next thing is you'll have somebody bring in a breach of privacy action because they'll find that the recording of the employee not went only to the boss, but it went to a claims handler and it went to solicitors and it went all over the place. So just be careful about that. My gut instinct on that is no. I don't think it's a good idea. I think if there is CCTV footage in the shop, fine. I do have one case where a very, very competent lady did actually do that and did take out she didn't put the video on, but she knew trouble was coming, and so she got the voices recorded. But she didn't video the people, so you couldn't see their images, but you could hear them talking. And that was mashed with the CCTV footage, which didn't have sound, which proved to actually be very useful. But I'd be very cautious about it. And you wouldn't want to be a really big retailer with CCTV footage and security guards, because that would not be considered to be, if you're talking about a one owner shop, a Spar shop or a Spar Centra, and they wanted to sort of capture a scene that they thought was going to turn messy, maybe. But I'd say only maybe in those circumstances.
Okay, one more question from online forum. What are the rights of workers who have been the subject of slanderous social media posts by disgruntled customers? Maybe this is getting at the situation where a plaintiff posted this stuff that throws up.
Yeah, well, I have cases like that. I have cases where employees are suing their employer because in one particular case, somebody put an unfavorable video online and made a comment about the employee, and they're becoming slightly more prevalent than they had been, and they're very much there. The employer has normally reasonably good defense to that. The best thing an employer can do, so if it's put onto a public media, Facebook or whatever, something that you can get access to that has you know, a proper system.
Mhm.
The employer should be, in conjunction with the employee, should be writing to that form and asking them to take it down. There's very little else an employer can do, and you cannot force Google or Twitter or Facebook or any of these people to take things down. You can't do it. But I think if you were showing to a court that you had made your best efforts to get it taken down, you would reasonably.
One more has just popped up from Lorraine O'Neill. Thanks, Lorraine. Thank you for the session. Your view. Do we think that there will be any review of the current Defamation Act, bearing in mind it's from 2009, I suppose? Surely there's an appetite for considering the majority of judges dislike these cases. I mean, I'll just add on, any chance of getting rid of juries here, Shane?
I'm torn between a rock and a hard place. I really believe that people have an entitlement to a right to a trial by jury. People who brief me don't like me saying that because they think, yeah, but they're all mad. They're not, in fact, all mad. You'd be amazed. I have spoken to a number of juries quite legitimately when a case has been concluded for defendants, and some of them have given really good decisions and take it all very seriously. I think the feeling at the moment is, and I think in the Department of Justice, that certainly, yes, they want to abolish juries in civil actions. I think that's likely. I think that is unfortunate. I do think it's likely. In the circuit court, of course, it doesn't matter because it's a judge sitting alone. And do the defamation laws need reforming? Absolutely. Will they be? I think they'll be tinkered with again. And in real terms, the 2009 Act made no great difference in real terms. Okay, it tinkered a little bit. In fact, one of the things it did do, it reduced the statute, but in defamation actions, people don't wait for ages to issue proceedings. A, and B, all as it really did is increase the damages, potentially.
One final question is also about reform, but I think you just answered it. Listen, finally, I just want to thank you again for the talk. Very informative. And I'd like to thank everybody else for participating. We had over 120 participants, so we did very well there. Again, great to hear you speak with such passion about the topic. I have to say, my one key takeaway, Shane, from today was something you hit upon about your defendant clients who've been fighting these cases and winning. And certainly a theme that came through was, the plaintiffs don't often win in the circuit court, and the few examples are in the High Court. And maybe one of the takeaways, I think most of the participants in this talk have been insurance industry stakeholders, and maybe that's the message for insurance industry to think about fighting some of these a bit more. Would you agree with that?
I would entirely agree with that. I really do believe, and I'm not just saying it, I really believe that these cases are eminently winnable. And I think the more you win, the less appeal they have for plaintiff solicitors to take them, because if they realize that these companies are simply going to fight them, it's going to be potentially expensive in the short term, but I think it will pay greater dividends in the long term.
Excellent. Thank you so much, Shane. Just to remind everybody that the talk is recorded and it'll appear on the website, so you can access it there, as will the paper as well, I think, Shane. So thanks,
yes,
everybody.
I have a paper which I'll give to Lawrence and he can give it out at his heart's delight.
Very good.
For those of you who can't sleep.
And just to remind everyone, just look out at the website we'll email everybody about the next event as well. Thank you very much, Shane. Thanks, everybody.
Thanks, Billion. Very welcome.
Bye.
Bye-bye.
Thank you.